Mr. Wilkins said we must find a remedy against meritless suits, which of course raises the question, how do we figure out whether they're meritless? Who decides that they're meritless? On what grounds are they decided to be meritless? And they've dealt with that a bit in reverse onus. Following up a bit, they say a couple of the panelists suggested there should be complete immunity, no civil liability to anyone who is doing public participation. I mean, does that mean that, is that to be taken literally? Someone says, I don't like that developer, and I can say absolutely anything about him. He's a crook, his brother is a child abuser, he does absolutely anything. I mean, there's complete civil immunity. And if there isn't complete civil immunity, if it's a matter of, some of the other proposals have suggested, well, no, but the person who's bringing the suit must show that it's meritorious. So, okay, if I can prove those things are false, then you can't say them against me. Then doesn't that put you back into some kind of determination of the facts? I mean, there are lots of rules of procedure now, some of them mentioned, some of them like Rule 25, that says if a suit is frivolous or vexatious, it can be thrown out. If it's abusive, it can be thrown out. Bringing a suit to punish someone because it will be costly has been held in some cases in Ontario to be abusive. So why don't they get thrown out? They don't get thrown out because judges don't want to decide that kind of thing without hearing the facts, which means a trial, which means 5 years from now, which brings up the problem that has been mentioned by a couple of people. If it goes to trial, the defendant has lost, even if they win at trial. So how do you basically give judges the backbone to do something about it? Because our rules right now are full of provisions that would allow them to throw it out on day one. Except they say, I'm judicious, I can't tell. Yes, this looks funny to me, but I can't tell. I guess you work the reverse onus, but I mean, complete civil immunity sounds like, there are a lot of loonies out there. You can say anything. Sometimes it's true, a lot of the times it's not true. So how do you actually design a definition of SLAPP that can be seen to work? That a judge will recognize without a trial. I mean, that's one of the biggest things. You can do it. Reverse onus might be a part of it, but it's giving the judges the spine to do it is probably about 90% of the battle. Because right now there's a ton of remedies. Thank you.
I'm going to take a crack at that.
Well, you raised a number of, I think, really good points. I think the first issue is how do you define a SLAPP? And that issue, I think, is the one that I think for a trial judge is a challenge. But SLAPP suits have been defined in the literature as basically a frivolous or vexatious lawsuit where, the intention is really not winning the suit, but it's essentially to effectively get a gag order on the person or the individual or the NGO that is making the comment. So plaintiff's not going to win that, and the question is, how does the judge make that determination? And I think legal commentators who have looked at this issue said the starting point of that analysis has to be a legislative statutory right of public participation. That's got to be the starting point of the analysis. Now, your point is well taken that, do you want to set up a legislative scheme where we provide blanket immunity to anyone in terms of, they can say whatever they want and they would not be subject to civil consequences. Interestingly, in the U.S., where you have really a very strong anti-SLAPP legislation, they effectively have done that, and that's partly because in the U.S., they have the First Amendment, which guarantees the right to petition government. And the U.S. Supreme Court, in a decision called Omni, has held that the intent and motive of the SLAPP target in making the communication is really irrelevant. The only issue is, was the individual engaged in procuring government action? And the only exception to the protection is if, in fact, the person was engaged in what's known as sham petitioning, that their actions were really not motivated to secure government action. So in terms of providing immunity, it really exists in a broad spectrum. You have Australia, where the legislation, anti-SLAPP legislation, very clearly states that it does not apply to the law of defamation And on the other hand, you have Minnesota's legislation, anti-SLAPP law, which effectively immunizes any speech or conduct which is aimed in whole or part in procuring government action. In the middle ground, you have states like Delaware, Nebraska, Tennessee, and Pennsylvania, where they provide a limited protection against defamation. In those states where they've passed anti-SLAPP legislation, the protection is afforded, but except in cases where an individual has knowingly made a false statement or has been reckless in relation to whether it was false or not. So that's the middle ground.